welcome. I'm Rick Newman, Executive Director of the American Museum of Tort Law, with another of our continuing talks with interesting people on interesting and timely topics about the law. My guest today is Randy Barnett, the Patrick Hotung Professor of Constitutional Law at Georgetown Law in Washington, D.C. Professor Barnett is a noted constitutional scholar, author of several books and many articles. Among the books he's written are Our Republican Constitution, Securing the Liberty and Sovereignty of We the People, and The Structure of Liberty, Justice and the Rule of Law. Welcome, Professor Barnett.
Thanks for having me.
Well, so recently, the New York Times ran a series of articles by a number of constitutional scholars under the heading, How to Fix the Supreme Court. And you were one of the contributors with an article there. Several of the authors espoused fairly dramatic steps to fix the court, ranging from threatening to pack it to actually packing the court. You, he said, essentially, leave it alone. So my first two questions are, why? And does the Supreme Court need to be fixed?
Right. Well, I was invited in to provide the contrary opinion, New York Times's credit. I think that the broken court scenario assumes what we trial lawyers say assumes a fact, not an evidence, that the court is broken. Therefore, it needs to be fixed. I think many people think the court is broken because of the composition of the court, which was formed in completely licit and legitimate ways. And they're unhappy about the direction that the court is taking. But the court has moved over many periods of time in our history. And for many periods of time, those same people liked the direction that the court was moving. Now they don't like the direction the court is moving. There was a long time when I didn't like the direction the court was moving, and now I'm a lot more happy with it. So that's kind of the way it goes. And changing the rules when you are losing the game at that moment is really not the way to go.
Well, let me ask you about changing the rules, because I think what stimulated this series of articles, How to Fix the Court, is recent history. And as we all know, President Obama nominated Merrick Garland roughly 11 months before his re-election or his term was ending. And the Senate, led by Mitch McConnell, refused to consider the nomination. And ultimately, Trump filled that after he was elected. Very recently, a couple months before the election, after the death of Ruth Bader Ginsburg, President Trump nominated Amy Coney Barrett to the Supreme Court. And this time, the Senate, which had refused to consider Merrick Garland 11 months before an election, not only took up the nomination, but consented. So I think some people felt that that conduct was hypocritical, violated norms, and therefore it bespeaks the fact that the court, or at least the nomination process, is in some way broken. What do you think?
Well, there's a couple of things. First of all, it may well have been hypocritical. That's entirely possible. Shock news alert, in DC, politicians are sometimes hypocritical. But in my piece, I really wanted to address this issue because I think there's a distinction between the norms of the Senate and the norm of having a nonpartisan Supreme Court that has lifetime tenure. Those are two different norms. There are norms in the Senate, but there are also more fundamental constitutional norms about the way that the court is composed and how it's independent of politics and independent of the other branches. And we shouldn't allow breaches of one's form of norms to justify destroying one of our most fundamental constitutional norms. So that was the thrust of my piece. But I also contest this narrative. It starts the day before yesterday. Everybody's got their own favorite starting point. My favorite starting point would be where the Senate Democrats violated the Senate norm against filibustering judges, which was a very, very rarely used power, and began to routinely, systematically filibuster Bush administration nominations, President Bush's nominations, including what we now know for entirely political purposes. For example, the nomination of Miguel Estrada, which we know from leaked internal communications was done to precisely to keep him off the court because he was a Hispanic and would have been a strong candidate for the Supreme Court if he had gotten named to the confirmed to the Court of Appeals. In response to that, when President Obama came into office, the Republicans established a 60 vote threshold that the Democrats had established in order to block Obama nominees, the way the Democrats had blocked their nominees. There's a tit for tat strategy there. How did the Democrats respond? They used what's known as the nuclear option in order to abolish this filibuster for lower courts. But what is the nuclear option? The nuclear option is the option that says that the rules of the Senate can be changed by a mere majority vote, even though the rules of the Senate stipulate that you have to have a supermajority vote to change the rules. You do this by appealing to the chair. Now, this had been done before. It had been done by Robert Byrd, so it was not entirely unprecedented, but it was done this time. So they breached the norm of the Senate to change the rules of the Senate in order to eliminate the filibuster so that they can get, in particular, some judges nominated to the DC Circuit Court of Appeals. That was a second tit for tat. Republicans then escalated this when they refused to give a hearing to Merrick Garland, who was my classmate at Harvard Law School, one of the top members. He was my section mate at Harvard Law School, one of the top people in our section. We all looked up to Merrick, have a very high opinion of him. But they were completely within their constitutional power to do this. They have the power to advise and consent, and they refused to consent. They gave the reasons why they refused to consent, and those reasons, depending on who you listen to, were inconsistent with reasons they gave why they could consent to the Amy Barrett nomination. But there is more than enough norm change, norm destruction accusations to go around here. And it goes back a very long time. It didn't happen just the day before yesterday. In my view, none of this justifies changing the way the Supreme Court is chosen, change the terms of how Supreme Court justices are served, which is for life, and expanding the number of Supreme Court justices for partisan gain, for ideological partisan gain. Everybody knows that the number of Supreme Court justices is set by Congress. It is not unconstitutional for Congress to set the number of justices. It's been 9 for 150 years or more. It's a norm of 9. It's another norm, by the way. Mm-hmm. But there is a norm against expanding or contracting the number of justices to gain a partisan or ideological advantage. That norm was reaffirmed when Franklin Roosevelt proposed a court packing scheme for that very purpose. He had a cover story that the judges were overworked and they weren't, whatever, they were old, whatever his cover story was. But everyone, even in his own party, saw through the cover story. They knew what the reason was. They pushed back and they resisted that, and it was not done. He eventually got to take control of the court the old-fashioned way, by nominations. And he, right, at one point or another, had appointed 8 of the 9 justices, including elevating a Chief Justice.
Right. So there's really 2 strands going on here. One is the function and operations of the court itself. And the other is normative conduct in the Senate to get the Supreme Court created or appointed or filled or whatever. So first, is the Supreme Court becoming more political, or has it always been? I mean, I think it's sort of widely known now that the Supreme Court has a 5-4 or most recently 6-3 conservative majority. Should we be able to identify liberals and conservatives on the Supreme Court, or shouldn't we say they're impartial arbiters of justice, oracular beings in black robes who dispense justice from on high?
Well, as long as there is no disagreement about how Supreme Court justices should do their job, there is unlikely to be any partisan disagreement. And in the wake of the New Deal, there was a general consensus, a kind of what you might call a post-New Deal consensus about how justices should do their job. And it was something like a living constitutionalist idea, which justices should improve and update the Constitution so it reflects contemporary values. We all know the story of the Warren Court. We all know the story, which continues into the Burger Court as well, about justices completely disregarding precedent, and to get the right outcome, and being hailed as champions because they did. Then starting in 1980, with the election of Ronald Reagan, there started to be a contest or a dispute about how justices should do their job. And there were many, and in increasing numbers, and I am one of them, who believed that the justices should follow the original meaning of the text of the Constitution and they were not at liberty to update the Constitution to something that they thought would work better, or ignore the Constitution and do something else. So there has, since at least 1980, been a disagreement about what we might call judicial philosophy. When Robert Bork was nominated to the Supreme Court, and he was a self-professed originalist, then Judiciary Committee Chairman Biden said the judicial philosophy was relevant to his confirmation. I agreed with that then. I agree with that today. Judicial philosophy is among the characteristics or qualifications to be on the judge. How you would go about doing your job is a qualification for being a judge. What Democrats are objecting to is Republicans putting judges on the court who share their judicial philosophy. If once the parties get sorted out and parties are basically aligned behind different judicial philosophies, you're going to get Republican nominees that look a lot different than Democratic nominees.
Two questions. Number one, how do originalists interpret the Constitution when the Constitution is silent on something? For example, the word abortion doesn't appear in the Constitution. How would an originalist therefore address Roe v. Wade or something like that, or other areas where the Constitution is silent?
You have to take each issue that arises on its own merits, because it's all going to depend on which clauses may be implicated. There are clauses that have a more general meaning. The Privileges or Immunities Clause of the 14th Amendment, which courts have essentially read out of the 14th Amendment. The 9th Amendment to the Constitution is another unenumerated rights provision, which courts have essentially read out of the Constitution. The Due Process Clause, the Equal Protection Clause, these clauses do have meanings. Those meanings may or may not affect any given case or controversy, and an originalist would look at what the original meaning of those clauses are. Now, it's important to remember, not all originalists agree with each other about what the original meaning of these clauses are. We also don't necessarily agree with how specific they may be. Some people might think they're very general. Some people might think they're more specific. Just because you adopt a certain interpretive methodology doesn't mean you all agree on the results, any more than adopting the scientific method guarantees that scientists are going to agree on what the truth is. They're going to disagree. Scientific method gives them a means by which they evaluate each other's claims. Right. And that's what originalism does.
Good. Well, that leads to my second question, which is, if the judicial approach, whether it's originalist or living constitution, is material to the nomination of a judge or justice, what do we make of these recent hearings, which end up being sort of kabuki theater, where the nominee answers nothing to nobody, doesn't explicate his or her values, philosophy, anything, just sort of gives name, rank, and serial number?
Well, first of all, I'm not sure I agree with that characterization of how these hearings have gone. It's true that Democrats on the Senate Judiciary Committee keep asking about how particular cases should be decided, what the outcome should be in particular cases they care about. And that the nominees won't answer. And, every nominee of both political parties, Justice Ginsburg wouldn't answer them, Justice Breyer wouldn't answer them, Justice Kagan and Sotomayor, none of them will answer these questions as well. It's true, they're not getting answers to those kinds of questions. But we are learning a lot about what the judicial philosophy in general of these nominees are. But I will just say that what they say at their confirmation hearings wouldn't impress me that much, which is it doesn't impress me that much, whatever they say. I mean, Justice Kagan said we're all originalists now. I have a very high regard for Justice Kagan. I know her and I think very highly of her. That's an interesting statement she made. I think it's actually significant, but that doesn't really tell me that she's going to be an originalist justice, even though she says we're all originalists now. And so what I would want to see is I want to see a track record. I want to see a history, but that's before the confirmation hearings to tell me what kind of justice a justice is. And in the case of Justice Barrett, we had a lot of her writings, including some of which were critical of me. The writing she got the most criticism for was an article in which she criticized my book, Our Republican Constitution. Um, so I have a much better sense of what she thinks because of what she said when she wasn't running for, she wasn't a candidate for the Supreme Court.
Okay. And then I guess my final section of questions goes back to senatorial norms. Have we moved the needle? And if so, is there a way to get back to the old, more cooperative Senate? Or is this a broken institution that's so partisan that it's all out war between two factions?
I'm not sure that is really what the Senate is like. It may be what the Senate is like when everybody pays attention and all the interest groups and all the activists are focusing their attention on individual senators, and that they might behave differently. I think generally speaking, the Senate works pretty collegially in the sense that most of the work is done by unanimous consent. What every side always threatens if they don't get what they want is they're not going to do unanimous consent anymore, and that'll make the Senate grind to a halt. Well, that just tells you that normally things are generally done by unanimous consent. Changing the rules of the Senate to eliminate the filibuster for legislation would fundamentally change the character of the Senate as a bipartisan institution where things don't get passed unless there's bipartisan agreement. The reason the Affordable Care Act got passed is because for a brief moment, Democrats held on to 60 Senate votes, and they could put anything they want through. And we got a partisan, one-sided healthcare bill because of that. But normally that doesn't happen. And therefore, things don't get through the Senate unless they're bipartisan. If you make the Senate a majoritarian institution, which is what's been proposed by eliminating the filibuster, and I believe it's what would happen if the Democrats actually control the Senate and the White House, they will abolish the filibuster for legislation. If you do that, then the Senate becomes no different than the House. And as everybody knows, the House is basically run by leadership. Individual members have virtually no say in what goes on in the House. And senators do, because the filibuster gives each individual senator more power to veto things. As a result, it is a more collegial body, even though when all the cameras are pointed in their direction, it doesn't look that way.
Well, as we sit here, the election was a couple days ago. There still has been no announcement as to the Senate results or the next president of the United States. So the court packing, if it were to happen, could only happen if the president is of the same party as the Senate majority. In other words, if Biden were to win and the Democrats control the Senate, they could do court packing. Without that unanimity, am I correct in saying we don't have to worry about packing for the near future unless there's that control?
No, absolutely. If the Republicans retain control of the Senate, there's all kinds of things we are not going to be debating over the next 2 years that we otherwise would have been. The filibuster in the Senate, court packing, term limits for the Supreme Court, repealing the Trump tax bill, the tax cuts. The list is long. Oh, the admitting the District of Columbia and Puerto Rico as states with 2 senators apiece. That would be pretty much permanent Democratic senators. We're not going to be debating that. We will, if the Republicans lose control of the Senate, if the current projections don't hold up, for example, if they lose the runoffs in Georgia, that's all we're going to be debating for the next 2 years. We're not going to be debating healthcare policy. We're not going to be debating fiscal policy. We're going to be debating these efforts to fundamentally change the nature of the United States government and our constitutional order. So we may have dodged a bullet on election night, contrary to projections, and we could be then talking about policy that the Biden administration would want to see implemented, rather than all these other things, many of which I don't think that Joe Biden himself wants to see us debating, but I don't think he'd have much control over that if, in fact, his party controls the Senate as well as the presidency.
Interesting. Well, we will wait for the next couple days and try to get the results. Professor Barnett, thank you very much for talking with me this morning. I think this is fascinating stuff. I really appreciate it. Thank you.
Well, thanks for having me. I do think that the Senate results may have turned out to have been more momentous in terms of the direction of the country than the presidential result will be.
We'll find out. Thanks again.
Find out. Okay, bye-bye.